And we're following breaking news just coming into CNN right now. Attorneys for former President Donald Trump say they're unable to get a bond to pay the $464 million fraud judgment, calling it, and I'm quoting now, a practical impossibility. CNN's Kara Scannell is joining us from New York right now. Kara, what can you tell us? Walk us through what this means.
So Trump's lawyers have informed the appeals court today that they are unable to get anybody, an insurance company, an underwriter, to help them post this bond, the $454 million for Trump alone, the rest to cover his sons.
Welcome back, everyone. David Stone is here. Let's break down the latest development. A prominent bonding firm informed Trump that securing a bond for his $454 million civil fraud judgment would require $1 billion in liquid assets. In response, his legal counsel returned to court and conceded that fulfilling this demand is strictly impossible for him. He doesn't just refuse to pay, he physically is unable to do so. A figure whose whole public persona is rooted in immense wealth just had his attorneys confess to a federal judge that the cash simply isn't there. Take a moment to process that.
In fact, it helped make him president. Well, surprise, surprise, it turns out he's not as rich as he claimed to be. Trump's lawyers informed the court today that he has not been able to secure a bond for the $464 million judgment against him and his co-defendants in the New York civil fraud trial. His lawyers now say that getting a bond in the full amount is a, quote, practical impossibility after reaching out to some 30 companies. They say that that's because most companies will not accept his properties as collateral and instead are looking for cash to cover the bond.
The resulting paperwork exposes a massive void between the image he projects to the world and his actual private circumstances. This discrepancy was severe enough that a bonding firm reviewed his purported fortune and declared, "We need $1 billion in cash equivalent collateral to feel secure." Faced with that exact stipulation, Trump's response was, "I cannot meet it." Let's dive into the official court documents, as the specifics are truly mind-boggling. Judge Arthur Engoron oversaw a complete bench trial. This wasn't just a basic motion hearing or a quick summary judgment, but a comprehensive trial featuring witness testimony, physical evidence, and cross-examinations. Following those proceedings, Engoron released an official, written verdict determining continuous corporate fraud.
A cash crunch for a self-proclaimed multi-billionaire. Former President Trump's lawyers saying Monday he doesn't have enough money on hand to pay the $464 million civil fraud judgment against him and can't secure a bond. Mr. Trump has until next Monday to post that bond, or the New York Attorney General can seize his assets to satisfy the judgment, which he is appealing. In a statement overnight, Trump calling a bond of this size, quote, unprecedented and practically impossible for any company.
Consequently, the monetary punishment was colossal, roughly $355 million before adding interest. Once the final math was completed, the grand total sat around $454 million. Furthermore, that penalty is accumulating interest on a daily basis at a rate of $87,000 each day. You heard that right. An extra $87,000 is tacked on to Trump's legal obligations every 24 hours as his appeal navigates the legal system.
New York's Attorney General says she is ready to seize former President Trump's assets if he is unable to cover that $355 million judgment against him. Tish James says she wouldn't hesitate to seize one of his buildings, like 40 Wall Street, if necessary. She spoke with ABC's Aaron Katersky and says she is confident in the strength of the case, which the Trump team has vowed to appeal.
So if he does not have funds to pay off the judgment.
However, the initial ruling represents just one part of the narrative. The remaining piece revolves around the consequences of a defendant refusing or lacking the ability to pay. Enter New York Attorney General Letitia James. She holds a tool that Trump has rarely encountered, an official, systematic enforcement strategy designed to treat him no differently than any other citizen carrying a $454 million debt they are unable or unwilling to settle. Let's break down this strategic playbook. The initial phase involves filing the judgment with local county clerks, a move James has already executed. By registering the penalty in Westchester County, she took direct aim at the Trump National Golf Club Westchester, along with the Seven Springs estate. Consequently, a public record of this massive debt.
Good morning, Margaret. Former President Trump's lawyers say he will not be able to secure this bond by Monday's deadline. And there could be a delay tactic or an appeal they announced in the next 24 hours. But it's very clear that at this point they don't have the money to put up, even though Trump's trying to maybe use the merger of his social media company to get some leverage here. It is clear the Attorney General of New York is moving very aggressively, already has a file in Westchester County to begin the process of seizing assets in that area of New York, and she could use a marshal or a sheriff to begin freezing Trump's bank accounts and taking prized properties like Trump Tower and 40 Wall Street in the coming weeks.
The third phase focuses on procuring writs, which grant sheriffs the power to confiscate funds and physical property. At this juncture, the process transitions from mere documents to tangible consequences. Bank balances are locked, assets are forcefully removed, and the harsh truth of civil penalties can no longer be brushed aside. The fourth and final phase initiates the sale or foreclosure of these properties to cover the unpaid balance. This represents the absolute finish line, where luxury estates, golf resorts, and even towering skyscrapers are auctioned off to satisfy the financial penalty. This is the point where the situation reaches a theatrical peak.
This morning, Donald Trump facing a massive $355 million fine, once again comparing himself to Alexei Navalny when asked about his legal bills.
How will you put up that kind of money because you have a bond to put up? Even if you appeal, you got to put up escrow money. That's it's a lot of dough.
It is a form of Navalny. It is a form of communism or fascism.
After days of silence, Trump now calling Navalny's death a sad situation.
During an interview with ABC News, James stared straight into the lens and clearly stated that if Trump doesn't possess the capital to pay the penalty, she will initiate collection procedures and petition the judge to confiscate his holdings. More notably, she singled out skyscrapers, not sprawling estates or country clubs. She highlighted the very high-rises that cemented his reputation as a formidable New York property tycoon. Consider the gravity of that moment. The top legal authority in New York announced on national television her readiness to take over Trump Tower if required to settle the debt. We aren't talking about empty intimidation tactics here. This is a definitive declaration of legal intent from the most powerful law enforcement official in the state. Let's pivot back to the struggle over the bond, as this was the catalyst for unmasking his true financial standing. The appellate court offered Trump a brief reprieve, stating they would halt collection efforts provided he supply a discounted bond of $175 million inside a 10-day window. Dropping the requirement from $454 million was a massive concession, leading many observers to frame it as a massive win for the former president. However, a crucial detail slipped past the public's radar. Securing that safety net meant approaching bond agencies, who reviewed his fiscal health and outlined their strict demands to his legal counsel. Their asking price? $1 billion in cash equivalent collateral. That figure is over double the court penalty and twice the amount he is legally required to pay. These agencies recognize a truth that Trump's meticulously crafted persona attempts to conceal. Real estate cannot be spent like currency. Buildings do not equal liquid capital. You aren't allowed to settle a $454 million fine by handing over Mar-a-Lago, nor can you drop the deed to a golf course on a judge's desk to clear your debts. The courts demand genuine currency, accessible bank balances, and liquid wealth, prompting bond issuers to demand security well beyond the assets Trump claimed to hold. Consequently, his attorneys returned to the appellate judges and officially documented his inability to finalize a bond under such conditions. The phrase "could not," buried inside a legal brief crafted by his own counsel, remains the most devastating revelation of this whole ordeal, primarily because the words originated from his own camp. This wasn't dug up by rival campaigns or spun by news anchors. It was Trump's chosen legal representatives notifying the justice system that their client lacked the fluid capital a bonding agency deemed necessary. While the appellate court eventually permitted the lower bond amount, the severe reputational blow had already landed. The concession became a matter of public record, allowing financial backers, loyalists, political adversaries, journalists, and everyday citizens to read precisely what his lawyers admitted. We need to discuss the impact this has on the facade of his billionaire status, as this narrative extends far beyond mere vanity. It serves as the bedrock of Trump's entire political persona. He presents himself as the triumphant entrepreneur who masters every negotiation. He's the affluent outsider, immune to corruption, because his wealth allegedly dwarfs everyone else's. He's portrayed as an economic mastermind who constructed a vast empire. Yet the struggle to secure this bond blew a massive hole through that very legend. A true billionaire, one with actual liquid capital, would not break a sweat securing a bond representing a mere fraction of their purported fortune. An authentic billionaire wouldn't face a bonding agency demanding collateral worth twice the actual penalty. A legitimate billionaire doesn't send attorneys into a courtroom to declare an inability to satisfy standard underwriting requirements. This entire dispute over the bond highlighted the stark contrast between total net worth and readily available cash. Whatever Trump's total value may be, it is deeply locked inside property investments. Real estate famously ranks among the least liquid asset types available. Turning a massive high-rise into spendable cash within 7 days is impossible, just as liquidating a golf club to cover a Friday court deadline cannot be done. The very buildings that pad his apparent wealth on paper are exactly what leave him starved for cash when a massive legal bill arrives. None of this is guesswork. It's fundamental economics. The bonding agencies understand it, the judicial system recognizes it, and due to the admissions of his own legal team, it is now forever cemented in the public record. Let me outline the math regarding the daily accrual, as this is exactly where the financial vice truly tightens. Every 24 hours, $87,000 in interest is stacked onto the total penalty. As the appellate process drags on, as attorneys debate and as judges deliberate the details, the total owed continues to swell. A single week of legal maneuvering piles on over $600,000. Give it a month, and the total jumps by upwards of $2.5 million. Should the appeal stretch out for an entire year, a common timeline for these proceedings, the penalty inflates by over $31 million before the judge even pens the final decision. This compounding financial pain is the exact mechanism designed to force a swift resolution. Trump doesn't have the luxury of endless delays, as every passing sunrise inflates his financial burden. With each day the appeal stays alive, his eventual payout expands. Should his appeal fail, he will be responsible for the initial fine alongside every dime of that compounded interest. While the appellate judges temporarily halted asset confiscation, they certainly didn't freeze the interest accrual. The meter is still ticking, the grand total is still climbing, and the squeeze on his finances only grows stronger. We need to examine how this impacts Trump's broader political campaigns and courtroom battles, considering both machineries require massive funding. Running for office is expensive, and fighting criminal charges burns through extraordinary amounts of cash. The unveiling of his liquidity crisis during the bond dispute achieved a blow that opposition commercials could only dream of landing. It placed on the permanent record that his accessible capital falls vastly short of the wealthy facade he projects. Contributors pay close attention to these developments. The major financial backers, the individuals signing seven-figure checks, refuse to toss their funds into a bottomless pit. They prefer investing in victorious candidates and backing leaders possessing the financial stamina to endure brutal campaigns. Watching his own attorneys admit to a judge that meeting collateral demands was impossible prompts these donors to start raising concerns, asking questions he would heavily prefer to avoid. His political partners are also taking notes. The very loyalists who defended him across dual impeachments, endless inquiries, and massive institutional pushback are beginning to question the actual strength of his financial bedrock. These politicians are weighing their personal careers, questioning if tethering their fate to an individual facing imminent state property seizure is a wise move for the long haul. His legal defense network faces an even more immediate threat. Trump is currently battling numerous separate criminal indictments, with every single trial necessitating a dedicated team of lawyers expecting timely compensation. Those massive legal bills must be cleared no matter how this separate civil penalty shakes out. Should this current judgment trigger bank freezes and asset liquidation, gathering the funds required to keep his criminal defense attorneys paid will become drastically more difficult. Next, let's deconstruct the illusion of the invincible tycoon. This specific narrative shield has insulated Trump for decades, pushing the concept that his limitless financial reserves elevate him above standard regulations and allow him to drag out legal battles eternally. The clash over the bond, combined with the detailed collection strategy, utterly dismantles that armor. The current enforcement protocol addresses Trump precisely like any everyday debtor. He faces the identical filing procedures, the exact same lien powers, the standard writs, and the usual foreclosure tactics. The Attorney General of New York made it abundantly clear that she will execute the very same collection methods against him that she would unleash on any other person defaulting on a $454 million debt. That equity is the fatal blow here. The devastating part isn't the sheer size of the penalty or the daily interest accrual, but rather the parity, the realization that the justice system is holding him to the exact same standards as the rest of the public. A judge confirmed his liability for fraudulent business practices, and the collection gears are turning just as they would for any other guilty party. For years, Trump has broadcasted the narrative that he faces unprecedented bias, arguing that courts, attorneys, and the entire structure are unfairly stacked against him. However, this collection process holds no bias. It is purely mechanical and strictly procedural. It follows the precise blueprint utilized for any individual losing a $454 million civil fraud case. That uniformity is exactly what makes this moment so destructive to his public image. The single argument he cannot utilize is that the collection framework is singling him out for unique punishment. It is processing him uniformly. For a figure who constructed a massive political movement entirely upon the premise of operating outside the standard rulebook, being handled like a normal citizen is a catastrophic blow. Let's explore the key markers to monitor as this narrative unfolds, given that the upcoming months will dictate if this collection process hits its final, extreme outcome. First, keep a close eye on the appellate hearings. Contesting Engoron's decision represents Trump's strongest opportunity to shrink or erase the penalty. Should the appellate panel validate the initial fraud verdict and the total fine, the collection machinery will speed up. Conversely, if those judges alter the ruling by lowering the financial hit or overturning specific violations, the trajectory of the enforcement shifts entirely. This appeal acts as the crucial fulcrum. The entire situation hinges on the appellate court's final ruling. Secondly, monitor the daily interest accrual. Adding $87,000 every single day accumulates rapidly, and as that mountain of debt climbs, the urgency for Trump to secure any kind of settlement skyrockets. Eventually, the owed amount could swell so massively that a victorious appeal on the core arguments won't save him, since the interest generated during the legal delay might remain enforceable despite reductions to the base fine. Thirdly, pay attention to James's active collection measures. The legal paperwork is already filed in Westchester County, meaning the subsequent phases involve property liens, writs, and foreclosure protocols. Every single action demands a court filing, making the documents accessible to the public and visibly demonstrating the slow, crushing progress of the state's collection apparatus. The moment she submits a writ directing sheriffs to lock down bank accounts, it will signal the final chapter has opened. Finally, observe the subtle shifts among his financial backers and political defenders. If prominent contributors begin shutting their wallets, the news will undoubtedly leak. When allied politicians begin inching away, the shift will become apparent through their public rhetoric and backstage maneuvering. The sudden revelation regarding his lack of accessible cash is exactly the type of shockwave that alters private alliances well before it impacts outward loyalties. Let's synthesize all of these facts based strictly on what the official records confirm. The Engoron verdict stands as a formalized, published legal ruling declaring continuous corporate deception. Registering the debt in Westchester County represents an executed legal maneuver aimed directly at pinpointed real estate. Trump's personal legal team informed the appellate judges that securing a bond demanded $1 billion in cash equivalent backing, a sum vastly exceeding his acknowledged liquid funds. Letitia James unequivocally stated on ABC News her intent to confiscate property, specifically calling out high-rise buildings, if the penalty remains unpaid. The entire collection blueprint, spanning from initial filings to liens, writs, and ultimate foreclosure, is officially chronicled and open for public review. The daily interest continues to accrue at $87,000 for the duration of the appeals process. Each piece of this puzzle is fully authenticated. Every single detail stems directly from legal dockets, authoritative declarations, or leading media outlets. All of it is cemented within the official institutional archives. Discussions regarding the court taking control of Trump's assets are far from mere guesswork or future forecasting. They are accurate depictions of collection protocols that are currently active, heavily papered, and openly verified by the officials leading the charge. We are no longer questioning if this collection apparatus is real. It undoubtedly is. We aren't guessing whether James promised to utilize it. She certainly did. We aren't debating if Trump's own legal counsel confirmed his cash shortage. They explicitly put it in writing. The true uncertainty lies in the aftermath of the final appellate ruling. Should Trump's appeal fail, the collection machinery will simply pick up right where it paused. The authority to place liens is already established. The necessary writs can be pursued without delay. Foreclosure protocols could kick off in a matter of days. Financial accounts stand to be locked down, and physical real estate could be taken by the state. The iconic towers that serve as the bedrock of his global brand could be auctioned off to clear the massive debt. None of this is an exaggeration. It is merely the civil penalty system functioning precisely how it was engineered to operate. It's the identical framework utilized against any ordinary citizen defaulting on a $454 million court order. The legend of his invulnerable wealth has suffered a devastating blow that might be permanent. This damage wasn't inflicted by the attacks of political rivals or the columns penned by reporters, but rather by the mandatory courtroom confessions of his own legal team, the rigorous financial demands of a bonding agency, and the very public declarations of the New York Attorney General. His affluent persona always contained elements of fantasy, but today that fantasy is legally archived. The massive chasm separating his projected image from his true financial state is permanently logged in court documents, all while the state's collection engine keeps turning. We are witnessing a historic juncture where the justice system handles a former commander-in-chief no differently than an average civilian. It's a reality where standard regulations stick, massive penalties are collected, real estate is vulnerable to seizure, and bank balances can be paralyzed. This specific milestone truly reshapes the entire landscape.